All right, so get this. We got a request to dive into this legal battle that's brewing over ferric carboxymaltose.
FCM.
Yeah, FCM. It's an iron supplement. But this case is, wow, it's a wild ride. Like, it could seriously impact how drug patents work globally.
Oh, absolutely.
We're talking, Vifor International Limited and ANR, MSN Laboratories, PVT, LTD and ANR.
Among others, yeah.
And others, yeah, exactly.
It's a fascinating case because it really boils down to this sort of fundamental question, right?
Yeah.
Does a patent protect like the actual product,
Yeah.
or just the way that that specific product is made?
It's like if you invent a new type of cookie,
Right.
does your patent protect like all cookies of that type, or just like your exact recipe?
Exactly. Yeah. And in this case, the cookie is FCM, and the company that's saying, "Hey, this is our cookie, this is our patent," is Vifor,
Okay.
and they're up against some pretty big players in the pharmaceutical world. We're talking MSN Laboratories,
Mm-hmm.
Dr. Reddy's Laboratories.
Yeah.
All want to produce their own versions of FCM.
So, like, let's just break this down.
Yeah.
Okay. What is FCM? What's the big deal here?
Well, FCM is you can think of it as like a supercharged iron supplement.
Okay.
So it's used to treat iron deficiency,
Mhm.
especially for people who, they have trouble absorbing iron from like the regular supplements that you might find.
Okay. Yeah.
And Vifor, they developed this process to make it, they secured a patent for this specific process.
The patent number is IN 536.
IN 536, that's the one.
Yeah. Okay.
And that's where all the drama begins.
It's where the drama starts.
Because Vifor's patent, the way that they describe this FCM, they say it's obtainable from this very specific process.
Mm.
And the process involves using something called oxidized maltodextrins.
Okay.
And it really comes down to those two words, obtainable from.
Oh, okay.
Because Vifor is arguing that language, that obtainable from, that protects the product, the FCM product itself, no matter how you make it.
Okay, so they're saying, like, it's not just about their specific recipe, it's
Right.
about the cookie itself.
Exactly.
Okay.
But of course, the other companies are pushing back, right? They're saying, no. Look, your patent, Vifor, it only covers your specific recipe, not the cookie itself.
Right.
We should be free to, experiment in the kitchen, come up with our own ways to bake this cookie, as long as we're not following your recipe exactly.
Right, okay. And I know they bring up this idea of a rule of necessity in patent law.
Yes. The rule of necessity.
So what is that?
Well, the rule of necessity kind of kicks in when you've got this brand new product, something totally new. It's patentable, but the structure of it is like really hard to define. Think about like a new drug molecule, right?
Mm-hmm.
That's got this super complex structure, really intricate. Like it might be really hard to fully describe it chemically.
Yeah.
So instead of defining the actual molecule, what you do is you define the process for making it.
Okay, yeah.
So the rule of necessity, it lets inventors claim a patent based on that process that they use to create the product.
Okay.
That way their cool new thing, their invention is protected.
Right.
And so Vifor, they're claiming that FCM is a brand new product when they filed their patent.
Mm-hmm.
So they kind of had to describe the process,
I see.
because defining the actual product was too difficult.
Okay. But I think you mentioned earlier there's this case that kind of challenges how you can apply this rule of necessity.
You're right. The respondents, they're pointing to this big case, Abbott Laboratories.
Okay.
And that case really narrowed down the use of these product-by-process claims. It's like saying, okay, yeah, you can patent your fancy process, but only under certain circumstances.
Mm-hmm.
And you can't just, automatically claim the product itself just because you've got this patent on the process.
So are they saying that Vifor's case doesn't meet those the specific circumstances?
That's what they're arguing. Yeah, they're saying, look, Vifor shouldn't be able to just broadly claim ownership of the FCM product,
Right.
just because they have this patent on this one way of making it.
Okay, so this is like, it's a real tug of war here,
It is, yeah.
with each side kind of like pulling out different legal arguments, precedents.
Oh, absolutely.
And I understand that it gets even more interesting when you bring in kind of the international legal stuff, right? Because the judgment mentions a few other really important cases that deal with how this obtainable by language has been interpreted in different countries.
Yeah, they look at all sorts of different precedents.
So, like, let's dive into that for a minute. What other cases are they looking at?
Okay, well, for example, they cite Kieran Amgen.
Mm-hmm.
And in Kieran Amgen, the court basically said that if you come up with a different process for creating the same product,
Yeah.
that doesn't necessarily mean you've invented something new. So, like, just because you found a new way to bake a chocolate chip cookie
Yeah.
doesn't mean you've invented like a whole new type of cookie.
Right. It's still a chocolate chip cookie.
Exactly.
Okay.
So the question here is making FCM through a different process, does that really create a distinct product, like legally speaking?
Right. Okay. Cool. What other cases did they look at?
Well, they also considered Hospira UK Limited.
Okay.
And Hospira really grappled with this subtle but super important difference between obtained by and obtainable by.
Mm-hmm.
When you're talking about patents,
Yeah.
it's fascinating how like just a slight change in the language
Oh, yeah.
can have these huge implications.
It's like those grammar rules from school suddenly mattering in the real world.
Exactly, yeah.
Yeah. Okay.
And then there's another case, Generics UK LTD-VH Lundbeck AS.
Okay.
And that case, it kind of gave this historical perspective on how these product claims have changed over time.
Mm-hmm.
It helps us understand like how this whole debate, this product versus process debate has evolved.
Wow. So it's interesting how this case, which seems, kind of specific about FCM, this iron supplement,
Right.
it brings in all this this global legal stuff.
It really highlights how interconnected patent law is.
Yeah.
Especially when you're talking about, a global industry like pharmaceuticals.
Right.
And of course, we can't forget about, the specific laws of India,
Right.
where this case is actually being decided.
Yeah, because the Indian legal system, they must have their own rules and interpretations when it comes to patents.
Oh, yeah, for sure. And the Indian Patent Act, it plays a really crucial role here.
Okay.
So the judgment, it really analyzes these key parts of the act, like, Section 21J.
Okay.
And that section defines what counts as an invention.
Right.
And then there's Section 10.4, which deals with the clarity and the scope of the patent claims.
Mm-hmm.
And then there are Sections 48A and 48B.
Okay.
And those sections differentiate between patents for products and patents for processes.
Right. Okay. So they're really like piecing this puzzle together.
Exactly, yeah.
Right. With each piece of this Indian Patent Act representing a different part of the puzzle.
That's a great analogy.
Okay.
They're looking at each little piece of this legislation, trying to see how it fits into, the overall picture.
Mm-hmm.
This whole question of, does Vifor's patent cover the FCM product or just their specific process?
So after all of this back and forth, all these legal precedents, the analysis, what did the Indian court actually decide?
Right. Who won this round?
Yeah.
Well, in a bit of a twist,
Yeah.
the Indian court actually sided with Vifor.
Oh, wow.
Yeah. They ruled that if you've got a genuinely new product, even if you describe it at first by how it's made, by its process, that it shouldn't automatically mean it's just a process patent when it comes to, infringement.
So it's kind of like saying, look, even if your initial patent focuses on the how, someone else can't just waltz in and just copy the what if the result is basically the same thing.
Yeah, that's a good way to put it. The court seemed to be saying, just because Vifor had to initially describe this new FCM product by laying out how they made it, that doesn't mean other companies can come in and just make basically the same thing, even if the process is a little different.
Okay, so that's a pretty big win for Vifor, wouldn't you say?
Yeah, it is. But it doesn't mean they got everything they wanted in the lawsuit.
Okay, so what happened? They won the battle, but not the whole war.
Right. So initially, Vifor was trying to get an injunction against the other companies, right, to stop them from producing FCM.
Okay.
And that was initially denied. But this ruling, it allowed Vifor's appeals.
Okay.
So they overturned that earlier decision, but they didn't actually grant a new injunction right away. They kind of left the door open, for Vifor to pursue it later on in the case, but they didn't just immediately say, okay, everyone stop making FCM.
So the legal saga continues then?
So it definitely does.
I think there's also this other interesting element to the case, right?
Yeah.
Something about the World Health Organization being involved.
Yeah, so FCM has been given what's called an international non-proprietary name, an INN,
Okay.
by the World Health Organization. And these INNs, they're kind of like the generic names for drugs, right? They're
Yeah.
used around the world to identify specific medications.
So it's like, for instance, if we think about the pain reliever paracetamol,
Right.
that's the INN, even though different companies might have their own brand names for it.
Exactly, yeah. So paracetamol is the INN, and then you have all these different brands that sell it under their own names.
Gotcha. Okay.
And so Vifor is using the fact that FCM has this INN
Mm-hmm.
to sort of back up their argument that FCM is a distinct and recognizable product. It's like they're saying, look, even the World Health Organization recognizes this as its own thing. It's not just a process.
Okay. That's a pretty clever move. But I'm assuming the other companies, they had something to say about that.
Oh, of course. They argued that the INN system isn't really meant to determine patent novelty.
Right.
It's more about, having a standard way to refer to medications regardless of who makes them.
Okay, so it's like saying, yeah, it's got a name, but that doesn't automatically mean it's this brand new thing
Right.
that deserves this broad patent protection.
Right. And it gets even more complicated because we have to remember those divisional applications that Vifor filed later on.
Oh, yeah, the divisional application.
Right. So remember, after they got their initial patent,
Mm-hmm.
they went and filed these divisional applications,
Mm-hmm.
specifically claiming SCM as a product.
Right. Just to like cover all their bases, right?
Exactly. It's a common strategy.
But I remember you mentioned that the other companies, they use that against Vifor. How so?
Well, they argued that if Vifor really thought that their initial patent already covered the product itself,
Mm-hmm.
why would they go through all the trouble of filing these extra applications later?
Right.
It kind of suggests that maybe initially they were really focused on the process, not so much the product. It's like if you didn't catch the cookie thief the first time, you set out more traps to try to catch them later.
Right. Gotcha. Did the court agree with that argument, though?
Not really. They acknowledged the divisional applications, but they didn't think that it really hurt Vifor's case.
Mm-hmm.
They seem more focused on the overall novelty of FCM itself, regardless of how Vifor's patent strategy kind of evolved over time.
Okay, so we've got these international precedents, debates over the specific wording, the Indian Patent Act, the World Health Organization, even strategic moves with patents. This case is like a legal thriller.
It's got it all.
What do you think are the most important takeaways from all of this?
Well, I think there are a few key things to really consider. First, this case really reaffirms the importance of these product-by-process claims, especially when you're dealing with these truly groundbreaking innovations.
Mm-hmm.
It's a win for inventors who are really pushing the boundaries, right?
Mm-hmm.
Especially in those fields where it's really tough to describe the product itself.
So even if you can only describe your invention at first by explaining how you made it,
Yeah.
you can still say, hey, this final product, this is mine, if it's truly unique.
Right, exactly. And the second takeaway, this case pushes back against this idea that process should always be more important than the product when we're talking about patent infringement.
Mm-hmm.
It really emphasizes that the focus should be on how novel and inventive the product itself is,
Okay.
not just on the method that's used to make it.
That makes sense. If companies were just focused on protecting their processes, that could really hinder the development of potentially better ways to make these valuable products, right?
Absolutely, yeah. This ruling encourages a more balanced approach. It says that innovation can happen in the what and the how.
Right, in both.
Yeah.
Okay, this whole deep dive has been fascinating. What's the one big question that we should be thinking about as we consider the implications of this case?
Well, I think the biggest question is how this ruling is going to influence future patent cases
Mm-hmm.
and innovation in the pharmaceutical world.
Mm-hmm.
Are we going to see a ton more companies filing divisional applications
Mm-hmm.
to try to really lock down those product claims? Or will this embolden companies to focus on developing truly novel products, even if those products are hard to define?
It's a great point. This could really have like ripple effects throughout the whole industry, affecting how companies approach patent protection, product development. It also makes you wonder about, how accessible and affordable these new treatments are going to be for patients.
Oh, absolutely. This case has really shown a light on how complex this whole world is, right? This intersection of patent law, pharmaceutical innovation, and public health. There aren't easy answers here.
Yeah.
And it's going to require a lot of conversation, a lot of collaboration to find solutions that work for for patients and for the industry.
This deep dive has really given us a lot to think about. Thanks for walking us through this really intricate legal battle.
It's been my pleasure.
It's kind of crazy to think about like the domino effect that this case could have. We've been
Hmm.
talking about how it might impact companies and their legal strategies, but what about the people who actually need these medications?
Yeah, that's a really important point. This ruling could have like massive consequences for patients.
Yeah.
Good and maybe some not so good ones too.
Right, right. So on the one hand, like if this encourages more companies
Yeah,
to come up with truly new drugs, I mean that could lead to a whole bunch of innovative treatments, right?
exactly. Yeah. Imagine like a future where you've got all these conditions that are tough to treat right now, and suddenly there are like multiple new drug options available. That'd be pretty amazing.
Yeah, that'd be great.
Yeah.
But then there's the cost issue,
Yeah, for
right?
sure.
And access. New drugs, especially the ones that are protected by these strong patents, they usually come with a pretty hefty price tag.
Yeah, you're not wrong. I mean, this ruling it could make it harder for generic drug manufacturers to get into the market,
Mm-hmm.
to offer those more affordable alternatives.
Right.
It's definitely something that policymakers and healthcare advocates are going to have to keep an eye on.
It's a tough balance, right? Because we want companies to come up with these groundbreaking treatments, but then those treatments got to be accessible to the people who need them, you know?
100%, yeah.
Yeah.
In this case, it really highlights just how intertwined all of this is, right?
Yeah.
Patent law, pharmaceutical innovation,
Right.
public health. It's complicated, and there's no easy fix.
Nope.
It's going to take a lot of talk and a lot of working together to figure out solutions that benefit everyone.
Well, you've given us a lot to think about. This case, it's so much more than just a fight over an iron supplement, right? It gives us this look into like the whole world of pharmaceuticals, patents, and this quest to find new and better treatments.
It's been great diving into this with you.
Absolutely. And to all of you listening, we hope you found this deep dive helpful.
Yeah.
Interesting. It's a good reminder that even these seemingly niche legal battles can have like huge implications. So keep exploring, keep asking questions, and we'll catch you on the next deep dive adventure.